Today I am going to share some legal information with all of you in regard with what is an FIR, who can file an FIR, whether the complainant can get the copy of the FIR free of cost, whether the complainant can withdraw the FIR, and what if the police officer refuses to register an FIR. So let us understand in this video details about all these questions. So first of all, what is an FIR? An FIR is a first information report that is prepared by the police on the information when they receive about the commission of a cognizable offence. It is a report that reaches the police first in the point of time. That is why it is called a first information report. Friends, under section 154 subsection 1 of Criminal Procedure Code 1973 makes it clear that FIR can be registered only in cognizable offences. It means that offences are classified into two categories. First, cognizable offences and another is non-cognizable offences. So it is very necessary to understand the difference between cognizable and non-cognizable offences. So before going ahead, let's understand this difference first. Friends, cognizable offences are those crimes in which police officers can arrest an accused without a warrant. Police officer get investigating right without the permission of the Honorable Court. Cognizable offences are defined under section 2 subsection C of Criminal Procedure Code 1973. The cognizable offences include very heinous nature crimes like murder, rape, kidnapping, theft, waging war against the government of India, dowry death. These are the cognizable offences. Now, what is a non-cognizable offence? Under section 155 of CRPC, under non-cognizable offences, police officers cannot arrest an accused without a warrant, and police officer cannot start investigation without the prior permission from the magistrate. The non-cognizable offences are defined under section 2 subsection L of CRPC, that is Criminal Procedure Code. Now, these crimes are less serious nature. The non-cognizable crimes include forgery, cheating, assault, defamation, and so on. Now let's understand the major difference between the cognizable and non-cognizable offences. Cognizable offences are non-bailable, whereas non-cognizable offences are bailable. Now, the next question is whether the complainant can get the copy of the FIR free of cost. The answer of this question is yes. A complainant can get the copy of the FIR free of cost, and this provision is specified under section 154 subsection 2 of Criminal Procedure Code. Section 154 subsection 2 makes it clear that any information that is recorded under section 154 subsection 1 shall be given forthwith free of cost to the complainant or to the informant. It means the complainant can get the copy of the FIR free of cost. Now the major question is, who can file an FIR? An FIR can be filed by the victim of the crime, a person who has the knowledge of the crime, or a person who is witness in the crime can file a complaint, can file an FIR. A police officer who comes to know about a cognizable offence or about the commission of a cognizable offence can suo motu file an FIR. Here, it means it is very clear that FIR can be filed by anybody, in the sense by a victim of the crime or anyone on his behalf. Now the question is, what if the police officer refuses to register an FIR? So, under section 154 subsection 3 of Criminal Procedure Code, the provision is stated, if an aggrieved person by refusal on the part of an officer who is in charge of a police station may send the substance of such information to the superintendent of police concerned in writing and by post, and if the superintendent of police satisfied that the information discloses the commission of a cognizable offence, in that regard he either himself start investigating the matter or direct the investigation to be done by his subordinate officer. If police do not register the complaint, in such regard the aggrieved person can also file a private complaint before the Honorable Court. Now, in this regard, there is some guidelines, or there are some guidelines issued by a constitutional bench of Supreme Court of India in the matter of Lalita Kumari versus State of Uttar Pradesh and others. In this matter, the Honorable Supreme Court stated the guidelines that registration of FIR under section 154 is mandatory when the officer receives the information of the commission of cognizable offences. A police officer cannot avoid his duty to register the crime when the information received to him discloses the commission of a cognizable offence. An action can be taken against an erring officer who do not register the complaint when the information received by him discloses the the offence or discloses the information of commission of cognizable offence. Friends, I specify here one another provision of Indian Penal Code. Under section 166 of Indian Penal Code, it is stated that a police officer who do not register an FIR in regard with the specific offences against women, in that regard, such police officer may be punished, and such punishment may extend to 1 year and with fine or with both. So now friends, another question, that is whether the what we can say now, that whether the FIR will what we can say, that whether the FIR can be withdrawn. The FIR cannot be withdrawn because there is no provision in law to withdraw the FIR. Because under section 154 of CRPC, once the FIR is registered, police officers under section 156 gets power to investigate the matter. and once the FIR is registered, it cannot be withdrawn because there is no provision in law to withdraw the FIR. However, quash petition can be filed before the High Court under provision of 482 of CRPC to quash the FIR. Now, many clients want to know that whether the FIR will get what we can say that whether the FIR gets FIR will lapse with the time. So the thing is that the FIR does not lapse with the time. It is because on the completion of the investigation, the police officer has to submit the charge sheet or a closure report in the court under section 173 of Criminal Procedure Code. Now, most of the client also want to know that what is a zero FIR. So here I explain you about zero FIR. A provision of zero FIR came up with a recommendation in Justice Verma committee report in a new Criminal Law Amendment Act 2013 after the heinous Nirbhaya case. Zero FIR, it means that it can be registered in any police station even though it does not have jurisdiction, even though the crime did not take place in that particular jurisdiction. It means that if a cognizable offense or if the informant goes to any police station to register the offense of or to register the crime in cognizable offense, the police officer will have to register the FIR without the jurisdiction, without the without incidents where the without considering the incidents, without considering the place where the incidents took place. Such type of FIR is called a zero FIR. It means that zero FIR can be registered in any police station. So friends, here I have explained you basic details in regard with the FIR. If you like this information, kindly share this video, like it and subscribe it. Thank you very much, friends.